section will focus on pregnancy as a disability. While the Americans with Disabilities Act does not specifically address pregnancy, many of the conditions that are pregnancy-related could be protected by the ADA, so you should be aware of some new developments in the law. The Pregnant Workers Fairness Act, or PWFA, is a landmark piece of legislation that aims to protect the rights of pregnant workers in the United States. Signed into law in December 2022, as part of the Consolidated Appropriations Act of 2023, the PWFA marks a significant milestone in the ongoing fight for workplace equality and fairness. This comprehensive act addresses the unique challenges faced by pregnant employees and ensures that they receive reasonable accommodation to continue working safely throughout their pregnancy, unless the accommodation would cause the employer an undue hardship. The PWFA builds upon existing protections provided by the Pregnancy Discrimination Act of 1978 and the Americans with Disabilities Act. It fills critical gaps in these laws by explicitly requiring employers to provide reasonable accommodations for pregnancy, childbirth, and related medical conditions. The ADA prohibits discrimination against an applicant or employee based on a disability, including a disability related to pregnancy. While pregnancy itself is not a disability under the ADA, some pregnant workers may have one or more impairments related to their pregnancy that qualify as a disability under the ADA. And of course, we have to provide reasonable accommodation for pregnancy-related disabilities. Recall that Title VII and the ADA cover employment discrimination in all aspects of employment, including hiring or the job application and selection process, pay, job assignments or promotions, training, employee benefits, or any other term or condition of employment, and firing from a job, reduction of hours, or a layoff. Under the PWFA, an employer must accommodate a worker's known limitation related to pregnancy, childbirth, or related medical conditions, of course, absent undue hardship. The PWFA also prohibits an employer from forcing a worker to take an accommodation, absent certain steps, and prohibits an employer from requiring a worker to take leave if there is another accommodation that does not cause an undue hardship that will allow the worker to stay on the job. Workers may also be entitled to accommodations under Title VII or the ADA. Recognize that the Americans with Disabilities Act covers a variety of pregnancy-related conditions when they significantly limit a major life activity. Some of these conditions include gestational diabetes, placental abruption, lumbar lordosis or severe back pain, deep vein thrombosis, embolism or stroke, carpal tunnel syndrome, mood disorders related to pregnancy, migraines, severe morning sickness, shortness of breath and fatigue, reflux, hemorrhoids, hypertension, urinary tract infections, and varicose veins. There may be other conditions that also may be protected by the ADA. These conditions could be considered disabilities under the ADA, requiring employers to provide reasonable accommodations. So work with your HR department to ensure that your employees' rights are being protected.